Welcome to TURK Fortune. This is Kaan, and today we will talk about the lack of legal grounds behind Turkey's so-called prohibition on payments in Bitcoin or crypto assets. So tune in if you are interested in accepting payments in Bitcoin within Turkey. As a reminder, on April 16, 2021, the Republic of Turkey took a small step to partially regulate Bitcoin and other crypto assets by publishing the regulation on non-usage of crypto assets in payments in the official gazette. One of the most important rules of this regulation, as you may realize from its title, was the prohibition of accepting crypto assets as a form of payment. In fact, paragraph 2 of Article 3 of the regulation reads exactly as follows. Crypto assets cannot be used directly or indirectly in payments. But is this really the case? Can such prohibitions only be imposed by issuing a mere regulation? Is there a real penalty waiting for the people who want to accept Bitcoin in return for goods and services? One of the points to note here is that regulation and law are two different concepts, and according to the Constitution of the Republic of Turkey, penalties can only be imposed by passing a law. In short, laws are hierarchically superior to regulations, and according to the Constitution, the only way to impose penalties is through a law, not a regulation. In this framework, we examined the law on the Central Bank of the Republic of Turkey and the law on payment and security settlement systems, payment services, and electronic money institutions, which are the underlying laws of the regulation that I mentioned. And no penalty was found. We did the necessary scans, but we did not come across any law that could be applied to a merchant who will accept crypto assets in payments. Were we missing something? Well, in order to eliminate this possibility, we decided to write directly to the Central Bank of Turkey, the institution that will implement the regulation. If they want to penalize merchants, they should at least know which law they are going to do it based on, right? To dispel any potential oversights, we asked our questions about the penalty for accepting crypto assets, the legal basis for such penalties, and the authority responsible for determining and enforcing these penalties. Luckily, the central bank responded quickly to the questions we sent, but their answers were rather vague and indirect, and kind of ambiguous. In fact, the response from the central bank did not answer any of our questions properly. In short, they gave us the following summary. Efforts to evaluate the regulation regarding services and transactions related to crypto assets continue with the participation of relevant institutions under the coordination of Republic of Turkey's Ministry of Treasury and Finance. As a result, in order to make a legal assessment regarding the issues mentioned in your request for information, it is necessary to make an official application to our central bank. In other words, they are still doing their homework. They are in cooperation with the Ministry of Treasury and Finance, and at the end of the day, there is not a single line of penalty clause that they can forward to me, even though I reminded them in my first message that penalties can only be regulated by law and they have to be public. And this official application necessity thing is kind of nonsense because my application was an official one under Turkey's law on the right to obtain information. But not to worry, because the vague and incomplete nature of their response actually works for us. Who seek clarification? How? I can hear you asking. Let's first take a look at the first paragraph of the Article 38 of the Constitution of Turkey. No one shall be punished for an action which a law in force at the time it was committed doesn't criminalize. No one shall be punished with a heavier penalty than the penalty prescribed by law for that offense. Now, let us read the paragraph 3 of the same Article 38. Punishment and security measures in lieu of punishment shall be prescribed only by law. The reflections of these two articles in the legal literature are known as the principle of non-retroactivity of laws and the principle of legality in punishment, respectively. In other words, punishment can only be imposed by law and it can only affect actions that have taken place after it has been imposed. As a result, we did not find any penalties in our own legal research, and the competent authority could not give us an answer as well. It should also be noted that the central bank's jurisdiction is defined by law, and it currently has no authority to impose penalties on just anyone they can find. No matter how much we researched, we couldn't find a penalty that could be imposed on those who want to accept Bitcoin or other crypto assets in return of goods and services. We consulted the most authorized institution pointed out by the relevant regulation on this issue, and they couldn't satisfy our curiosity on this issue. It seems that there's no real penalty that a person or company that wants to accept Bitcoin as payment in Turkey will be subjected to just because of this regulation. And there is a ban that is not clearly regulated the penalty. For now, it looks like merchants who want to accept Bitcoin and other crypto assets are facing a monster without teeth or claws. Yet, we will keep an eye on the policymakers and regulators in Turkey meanwhile, and we advise you to do the same, because the legal basis may change in time with an amendment or a new law. Thanks for watching Turk Fortune, and see you in the next video.